Good evening. Welcome to the first webinar in the Succession Planning for Woodland Owners series. I'm Liz Jackson. I'm a Forestry Extension Specialist with Purdue University, and I'm also Executive Director of the Indiana Forestry and Woodland Owners Association. We're glad you were able to join us for this very important topic. And now some housekeeping.
There goes Liz.
Thanks. The presentations will be recorded and sent to registrants after. I'll have a bit of a delay. I need to get those closed captioned and edited properly, and we will also share further reading information. If you would, please keep your microphone muted during the presentation, and we will take questions in the chat. Put those in at any time, and we can answer those at the end. Or at the end, you could also raise your hand, and we can call on you if you'd like to unmute. We ask that you don't share personal stories. We want to protect your private information. So if you have general questions or can generalize your specifics, that would be better. We don't want to divulge any private information. And a few caveats as well.
There's quite a bit of delay on that, Liz. I'm not sure why.
Thank you. These materials are intended to present general information on succession planning. It might not be applicable to every state and territory because it is very general, and this is not intended to be legal advice. If you need specific advice, you should check with an attorney or another professional well-versed in your personal information and also the jurisdiction where you're located. Those are important to consider as we move forward. And lastly, the upcoming programs next Monday at 7 p.m., same time. We will continue with Managing Family Dynamics, followed by the following two, Family Meetings, and the last one on Legal and Estate Issues. We hope you can join us for all four of those, but if you're not able to, again, we will offer those as recordings, so shouldn't be a problem to help you catch up. And finally, I'd like to thank the Purdue Succession Planning team. They volunteered to put their time to put this program together for us. They're quite experienced at doing these succession planning programs. And tonight we have two of the team members. Phil Woolery is an Ag and Natural Resources Extension educator from Pulaski and Stark counties in Indiana. And Kyle Weaver has the same role in Switzerland County. And Kyle, I'll hand the program over to you now.
All right. Well, thank you, Liz. And I do apologize. Seems like we're having a delay in our slide advancement. Phil, you might have to take over that. I'm not sure what the...
It's probably me. I need to stop doing stuff and you.
Okay, so hopefully that continues and we'll be successful with slide advancement tonight. But welcome to Keeping the Forest in the Family. And the plan tonight really is to talk about succession planning for forest woodlands and finding a way to get that property to the next generation and how important that is that you find steps to do that and you take those steps early as possible and you make it as successful as possible for you and also the successor. So we'll see if we can get our slides to advance. Here's the outline for tonight. We're going to talk about the importance of forest. We're going to talk about creating a legacy of forest, which many of you already have. We're going to talk about some general legal methods, and we're going to talk about a planning team and how those folks can help you to advance your succession planning of those forest lands and the importance of that. So here's what we know about Indiana forest land in the state. We know we have roughly just a little under 4 million acres, or 83% is privately owned. So why do we own those forests? Well, we know we do a lot of things with forest lands. We know it because it's beautiful. We have lots of wildlife. We have lots of folks in Switzerland County that love to go out and watch the wildlife and spend some time watching the white-tailed deer and all those kind of things. We also have lots of recreation in our forest lands and lots of UTV and ATV lands and trails and recreational trails and all those things that are running through our forest lands in the state of Indiana. And we also know that it's part of that legacy is passing that forest land on to the next generation. So that's why we have those forests. We want to keep those forests into private ownership. And that's terribly important when you're thinking about the legacy of forestry lands in the state of Indiana. So we think about our values and we think about it in terms of how does it influence how we operate when it comes to succession? And it really doesn't matter whether you're talking about a row crop farm or forest land or, a house and 3 acres. It's our values that are very important to us and they influence how we operate and it influences our management decisions. So if our ultimate goal is to pass that forest land into or woodland into the next generation, how do we do that? And how do we make sure that it's manageable for that next generation or those heirs to be able to take that property and be as successful as you were? And it also means that doing the things that are necessary. So going out and doing invasive species control and all the things that are necessary to keep a woodland up and current and available for recreation and lots of other things that we use our forest lands for. And it also inflects kind of our decisions. We're talking about financial decisions, and we'll talk about more about what your family looks like in just in a couple slides. But what do those decisions look like? And you're thinking about decisions that may be 5, 10, 20 years down the line, but they're decisions that will ultimately affect your family and the future of your forest land. So they're extremely important that those decisions are made, with lots of input and lots of people in your family making their choices made and having a really good plan and action. So we'll see some of that outline for that plan here in a few moments. So we know about our parcel size, and this is something that members of the association, I know we have many on tonight, know about this, but we know about our forest parcel sizes, they've been decreasing. And we know that just from the fact that we've seen a lot of sales of property that have gone on and we've taken 1,000-acre farm and turned it into lots and lots of smaller parcels and 30, 40, 50-acre parcels with the woods that have been split into 4 or 5 different sections, and that's just what we're seeing today. If it could be progress, it could be not, depending on your point of view, but that's just kind of what we're seeing in the state of Indiana today. And we know that inheritance also plays a big part of that. We're seeing especially in Southeast Indiana, the farms that were 500, 600 acres, sometimes 1,000 acres, that are now being sold because those individuals have passed on, and now we have the heirs that are taking over the property and they don't want to farm, or they're living off the farm and they're selling off those properties, and so we're seeing a lot of those forest lands just become smaller, and we know that when they become smaller, that they're kind of harder to manage because you can't get the equipment and the people in there for just a few acres of woodland. So it's important that we have some forethought, I guess is a good way to put it, in thinking about how do I make sure that woodland, that forest land is going to be something that's going to be available for the next generation. And we know that fragmentation, of course, is not good for the wildlife, and we are taking habitat that used to be very plentiful, and now it's no longer plentiful because we've taken some of that and put it into lots and other things that we still need, but we have to find a way to find a good moderate balance in there as far as having good property and being able to pass things on to the next generation. So when you're thinking about long-term management of Indiana forest lands, and this is something that I think when you look back at history, you're going to say, what decisions did I make today that will affect the next generation? And succession planning is just like that. And we know that our forests are product of decisions that were made maybe 100 years ago. And succession planning, we have some of those very same type of decisions that we make, because we're thinking about decisions that are going to affect my children, my grandchildren, and maybe a couple generations down the line as far as our forest lands, and making sure those forest lands are available for them to use. And hopefully they get the same enjoyment that you are currently getting off of that forest land. So we also know that what you're doing today, you may not see the benefit of. It may be something that, generations from now we'll see, and it may be 50 years down the line, it may be 100 years down the line. But again, it's about management that's going to help that next generation, and hopefully it's your successors that are going to be taking advantage of that forest land and seeing things in the future. Now, when you're planning for that next generation, we'll talk about a couple of things that are kind of important to that. Forest management decisions. So as you start thinking about I would love to have this, 50-acre parcel of forest land or whatever it takes, or whatever that size may be, and give that to my successors, my children, my grandchildren. What are those decisions you have to make today to make that happen? And we'll show you kind of some snippets and some spotlights on some of those decisions that you might make here in just a few minutes. And then it's those financial decisions. So when you start thinking about what's the easiest way to transfer that land to my successors, and we'll kind of give you some answers to those here in just a little bit. And we'll also, as you go through the program, the series, you'll get more and more specifics about how to do some of those financial decisions and why they're so terribly important. So the goal of estate planning is this. The goal of estate planning, again, it doesn't matter whether it's a row crop, whether it's you have a house on a couple acres, if it's forest land, the goals are really the same. You want to achieve your goals. So whatever your goal, whatever your vision is for your farm, your forest land, your woodland, whatever that is, whatever that looks like to you, it's achieving that goal that you have. And of course, the goal for most all of us is minimizing taxes. We don't want to pay the taxes ourselves. We don't want our future generations to pay those taxes. So it's finding a way to minimize those taxes that we have. It's also minimizing transfer fees and making sure that I can transfer that property to my successors, to my heirs, and we're going to minimize those fees they have to pay. And a lot of that, again, is forethought and trying to figure out what it looks like 20, 30 years down the line and how I can make that transfer as easy and as profitable for everyone as possible. So we have to take just a few moments and kind of think about our family when we think about succession planning. The family is so very important when you start thinking about succession, whether it's farmland, whether it's forest land, no matter what it is, you have to look at your family. And you do this in a couple of ways. You examine your family and you think about who the successor would be. One of the things that we see in succession planning is it takes about 6.5 years from the time you start thinking about succession planning till you finally get that accomplished in family situations. Many times we're seeing in succession planning 10, 15, 20 years down the line, we're seeing it taking it that long in order for succession planning to happen. So you have to examine your family. You have to identify who that successor may be. Is it one person? Is it several folks from your family? Is it a non-family member? So whoever that successor is, we have to examine that. And we have to examine, is there any reason why you might have a special need? Now, a special need could be, maybe you have someone in your family, maybe you have a sibling or a child in your family who, for whatever reason, should not get that parcel of forest land. And those are decisions you'll have to make. But it's about looking at your family and making sure that they're going to use and going to see your vision for that forest land and that woodland, as the succession planning process continues to happen. And 20 years down the line, they'll be able to enjoy it as well. And then you finally have to examine yourself, and you have to examine yourself in this way. If you get to the point in your life where you can no longer manage the forest land, meaning you may not be able to do the invasive species control you once did. You may not be able to keep up with the trails you have in your forest land. What's that option going to look like when you get to that point? Is the option to let the next generation, your successors, your heirs come in and take operation, management, and ownership of that parcel? Or is it that maybe you sell the property and you have to think about those kind of questions as we move forward. And the same thing worked with your spouse as well. So is your spouse willing to do those things, as they get older and we see things that have changed from generation to generation. So it's really about looking at those family members and seeing, if they can continue seeing the benefit of the forest land that you've seen. So we have what we call an heirloom scale. Excuse me. An heirloom scale is just this. So if we see the one with a dollar sign, it's about thinking about our forest lands. And do our forest lands, do we see those as a financial asset? Meaning, if I had a timber harvest and I get a really big paycheck, or I'm in, Hamilton County and I can get 50,000 an acre for a parcel of forest land and all those kind of things, do I see that as a financial asset? That's the one on the scale. Or do I see it to get to the 10 on the scale and I see our forest lands or our woods something that's kind of a family tradition and it's a legacy? We spent many, many times out there hiking the trails. We spent a lot of times on ATVs and UTVs going through our section of woods. And we spent a lot of time deer hunting. And deer hunting, our legacy, here in Switzerland County. So we have a huge deer hunting legacy, and folks will spend generations hunting at the same property, the same forest land, and that's a legacy there. So you have to think about, where are you on that scale? Do you see your forest lands as a good financial asset that we can make some money off of? Or do we see your forest land something that generations from now, we hope that they'll enjoy that? And it's something kind of like grandma's diamond ring, and we want to make sure we keep it in the family as long as we possibly can. And you could also certainly be somewhere in the middle. You could say, I know that I could keep this forest land for many, many generations, but we could also have a good timber harvest and kind of reap the benefits of that as well. So it's kind of where you fall in the heirloom scale. And again, it's in each individual's decision as to where they kind of fit on that scale. So we think about a shared vision, and we talk a lot about shared visions and succession planning, because you want your family members to share your vision for your property. And in some cases that works really, really well. In some cases it does not. But whatever your vision is for your property and your forest lands and your woodlands, you hope they share that vision. Now, if they do not share that vision, which sometimes does happen, there are a few alternatives that we can kind of think about. So, the forest is important to you, but it may not be important to your successor. So what things can you do? Well, you can sell the property now, or you can maybe sell it at death and reap those financial benefits. And you can use that for your own retirement. You can pass it on to your successors. All those things are options. Should that person not share your vision for that? You can do the timber harvest now, and maybe you get that really large paycheck and use it for your own retirement. You give it to your children, you use it as part of your assets for your transfer, your inheritance. All those things are certainly possibilities for you to do that. You can divide it equally. So if you have a couple kids and you want to divide a 50-acre parcel of woodlands, you can certainly do that. And you could do 25 apiece. That's certainly something that can easily be done. Or you can divide just the benefits, the financial benefits of selling off that property, and all those things work really, really well in case you have to do that. You can give it away. We have a lot of folks that will give property away, and we're talking about row crops, and lots of equipment gets given to the successor. And we always ask the question, if you have $1 million in assets and farm equipment, do you just give that to the next generation? In some cases they do, in some cases they do not. So there are ways to do that, and that'll be kind of part of what Phil will be talking about with your advisory team and finding ways to do that. Or you can just give it to one child. Maybe you have one child that really enjoys the forest land, spends a lot of time hunting and recreation out in that forest land, and you have another person that doesn't even set foot in the woods, and all those things are important for you to know. So maybe you just give that forest land to the one child, and maybe not the next one. You could have joint ownership. So if you have a couple of children, you can do those together, and sometimes that works and sometimes it doesn't, but we'll kind of outline that in the next slide. But there are opportunities for lots and lots of alternatives if they don't see that same vision that you might have as far as carrying that transfer into the next generation. So what does joint ownership look like to you? Well, you have to think about, what do your heirs really feel and think about joint ownership? And it comes down to this. If you have a couple of children, or maybe it's grandchildren, or maybe it's a combination of family members, how do they feel about owning it together? Because if you think about, I'm the youngest of 4 children, and I could joint ownership of anything with my sister. Now, my 2 brothers, probably not. But you have to think about your own family and think about, can we do this together? Also, if you're involving the next generation, those successors, think about those individuals. Can we involve those next individuals in those decision-making things, in decision-making meetings, and find a way to involve them in management decisions, ownership decisions? All those things are very important. And succession plans, they will not work if the next generation is not on board. We as a succession planning team, we talk to many, many clients. We talk to farmers and producers all across the state of Indiana. And one of the questions that we often ask is, how does your next line of inheritance, or your next line of heirs, how do they feel about the farm? And are they willing to take on the ownership or management of the farm? And if that question's no, then the answer is, well, we look at someone else to maybe take the management and ownership of that farm. So succession plans, no matter whether it's forest land or cropland, you have to have that next generation on board for things to work successfully. So it goes back to the heirloom scale we talked about just a few minutes ago. So what does the next generation really think about the forest land? Does your children, do they see the forest land, or, we can make $50,000 an acre selling it off when mom and dad pass. And that'll be a great paycheck for us. And we're really going to think it's going to be a good financial windfall for my family. Do they think of it in that terms, or do they think, I remember going out hunting with my dad, when I was younger, and we'd spend lots of times in the woods. So then we're going to the 10 on the scale, and we keep it as kind of a family legacy. Or they're going to be somewhere in the middle? So you think about yourself on the heirloom scale, and where are you? How do you truly feel about your forest land? And what does the next generation look like in that same heirloom scale, and making sure that they see it as a financial asset or a family legacy? Those questions are important. Sometimes they're not the same answers, depending on where people are in their lives. We know many times that me as an owner of a forest land, maybe I have a little more financial backing and maybe have more financial rewards in my life than my younger children. And they could certainly use maybe some of that money that could come off selling of a forest land. So it's again about thinking about where we are and where they are, and where we kind of hope to meet in the middle if we can. So those questions need to be asked. So what does a plan, what does a general plan look like when you start thinking about succession planning? And it all begins with that first meeting or that first question, okay? And start thinking about and writing down your goals for the family and the property in the future, okay? So, you start those questions, at family meetings. You start thinking about, we have this section of forest land, we have the section of woodlands that we've been hunting and fishing in for many, many years. And what does it look like for you guys, the next generation? Do you want this property? Do you want to be able to continue to manage it? All those things are important. So, writing down those goals for yourself and for your family, and making sure that you can come to some sort of conclusion about why those things are important. You can discuss with your family, any kind of questions that you might have. And you can also create a plan to make sure everyone is on board. And I think Phil's going to talk about team meetings maybe in just a little bit, but it's important that you have everyone kind of on board with your vision and your plan for what that forest land and what that property looks like. And there are lots and lots of ownership and transition options that we'll see, and we'll see a couple tonight, but there are lots and lots of ways for you to do that. And that's part of what you and your family and your advisory team will do when you start looking forward. So we start thinking about, how can we get our heirs or successors to really develop a connection to our land? Well, you have to give them a reason to do that. It's kind of about that vision and thinking about, all the good times that you've had in the woods and the hikes and the ATV rides and in my case, this picture looks very familiar, but in my case, it was mainly chasing cows because we had a beef and dairy cattle farm here in Southeast Indiana. So we spent a lot of times in the woods chasing cows when they weren't supposed to be in there. But again, those are memories and legacies that we've had as a family. So give them a reason to hang on to that land. Involve them in those management decisions. Can you let your next generation, your children, your grandchildren, be part of making sure you're making the right management decisions that will affect them 20, 30, 40 years down the line? And it's important that you get their involvement and you get their input, just as you would for any succession plan. Are there recreation opportunities that maybe you're missing? Maybe it's putting that UTV trail through the forest land. Maybe it's putting some regular hiking trails through there. And it doesn't have to be a state park, but is it a way for you to get the extended family to come out and use those forest lands more often and really have an opportunity to make that legacy that you're hoping for? So we'll talk about what we call fair versus equal. We spend a lot of time in fair versus equal in succession planning because it's kind of an important concept. And when you think about fair versus equal, a lot of people will take their assets and they'll divide them equally between heirs. So if I have a 1,000-acre farm, I would give each child 250 acres and we call it good. Well, there are some very good benefits to that, and there are some ways that can be disadvantages to that particular system. But there are certainly ways that we do that. We call it sweat equity, and we don't use sweat equity much with forest lands. We use sweat equity a lot with row crops, because you think about the situation where one child or one sibling has stayed on the farm and managed the farm, and they've worked on this farm for 20 years, and the other three children are now off the farm. So you think about the sweat equity of the person that stayed on the farm and is managing that farm. Should they get a larger percentage of the farm, or should they get the entire farm when it's time for inheritance time and the parents have passed? That's kind of where the sweat equity comes in. You can also use the same concept with forest land. So if you have a child that loves to hunt in your forest lands and has been doing it for 20 or 30 years, and you have some siblings that have never, again, stepped foot in the woods, and it's just not their thing, which is totally fine. How do you break that up? And maybe you give that forest land to the person that really enjoys it. So all those things are important. You have to, again, look at the total picture of assets. Your portfolio is more than just the forest lands. Maybe you have some row crops, maybe you have some property, maybe you have real estate. So look at all those assets that you would have. And maybe that one child that loves the forest land, maybe you give that child the forest land, and your other children may get some other assets that you have. So you have to look at the entirety of your portfolio. Equal tenants in common could set the stage for a family feud. And here's why. So if you have a 100-acre parcel of woods, and you break it up between 4 children, you have 25 each. That may work out really well, but maybe the one child spends a lot of time in the woods and doesn't like that their siblings have ownership of the part of the woods or part of the woodlands that they've been managing and taking care of for many, many years. Because the last bullet, unfortunately, does come into play sometimes. That one tenant could say, I'd really love to sell off this property that we own together. And because they've started that process, then you have to go through the legal court process to determine whether or not we can sell that property, even though you may not want to. So all those things are kind of important when you start thinking about fair versus equal. And you will spend a lot of time as you're developing your plan, developing your goals, thinking about fair versus equal. So what's fair to each of my siblings, what's fair to the next generation, and what's equal? And you'll ask yourself those questions quite often. So what are the estate options that we have? It's important if you have forest land that you'd like to become part of the estate, that you make sure that it is part of the estate. So when you're talking to your financial advisors, your financial management team, making sure that forest is part of that estate. It could happen through wills. It could happen through trust. It could happen through LLCs. There's lots of different options there for you to do that. Again, we're not attorneys, and we want to make sure that you're consulting your advisory team in order to make those decisions when it comes to your estate options. So we'll talk about wills just real briefly. So if you have a will in the state of Indiana, or if you don't have a will in the state of Indiana, what happens? Well, we know that what should happen, and what often happens, if you pass, your spouse gets your estate, gets your assets, and that's usually what Indiana law says. If you have a spouse and child, it may be 50% goes to the spouse and 50% goes to your children. If you have children only, it may go, and it should go, equally to all of your children that you have. Then when you start getting into spouses and parents and spouses and children from previous marriage, it gets a little more complicated. But as you can see, what's important about this particular slide is that if you don't have a will, someone else is making those decisions for you. So part of succession planning is making sure you have your plan, your wishes are carried out. If you don't have an estate plan or will or any kind of estate planning document, someone else is going to make those decisions for you. That's extremely important that you know that. So that's why wills are so important. That's why estate planning is so important. Again, if it's something that you start today and you don't finish it for 30 years, a lot of things can happen in 30 years. So make sure you do it, and you take that first step, and you take that first step as quickly as you can. So let's look just a snapshot of taxes. And we know that federal estate tax, if you didn't know, it's just a little over $13 million for a single person, and then $27 million for couples. So that's your federal estate tax. So if you don't make over that, then you're pretty well in good shape. We know that Indiana does not have an inheritance tax, but when it comes to taxes, you do have to become aware of things like capital gains and step up in basis, and all those things are important when it comes to selling property or giving property away when you pass, and those are important discussions for you to have with your financial management team, and just thinking about ways to encourage your successors to be successful and making sure they're not paying more than they should back to the government. So we'll talk briefly about wills and probate. And this is something that you kind of know, it's reviewed for most people, but wills are just legal documents that express your wishes regarding your property. So it's your plan, it's your vision. You want the property to go to this child or all the children, and this is how you like for your property to be broken up. In probate, we have probate I know we'll have some legal representation in a couple of weeks, but it's just really the legal process of distributing assets through court supervision. And I've been through probate a few times with some family members, and it's not as scary as it sounds, but there is, you should have an attorney present for that. And it is the one thing that scares people about probate is that it is a public kind of opening event, so they can see, what your assets were and what your debts were and all those kind of things. So it scares some people to do that. And then we're thinking about avoiding probate. There are ways to do that. Again, it's part of those discussions you have with your financial management team and making sure that you can avoid probate. If that's what your plan is and that's what you'd like to do, finding ways to do that. And again, the step up in basis is something you certainly need to be aware of. And it's those discussions that you should have with those financial management folks that are helping you. So who goes in my will? We know this. You have an executor. That's that personal representative that's in charge that does your will and is putting the information out there, and it's getting the folks to see what your vision was and see where the property goes. So that's what their job is. You can also nominate a guardian if you have minor children. So who's going to take your children if something happens to you, maybe your spouse as well? Who gets all of your stuff, all the tangible, personable property, and thinking about all of the things that you have in your house and just all the stuff. And the next bullet's kind of important, and we've seen this in succession planning, is grandma's teacup is more important than the farm sometimes. Now, and we've had these discussions with families, there may be things in grandma's house or in your house that they really want. Maybe it's the china cabinet, maybe it's the teacup, maybe it's the pie plate, whatever that is on their mind, and that's what they would love to have. And they sometimes are more concerned about that than the real estate or the property and where that could go. So there are lots of decisions to be made, but these are your instructions. So you're able to break that up and let people know who gets what and where those should go. It also thinks about dividing your assets, including, funding of trust. I have a special needs adult child here at home, and we have to think about, when we pass, how are we going to fund his special needs trust? So all those things are out there, and trust are, again, a good tool that you could use, and finding ways to do that is also important to be able to divide your assets that way. So I think we're at a transition time where we're going to transition to Phil. And Phil, I cannot see the chat. Or does anybody have any questions? We have time for a question or two while we transition to Phil.
We do have some questions, so I'd be happy to send them your way.
Sure.
Rachel asked, will we cover the multitude of reasons, benefits to keep the woods in the family? Benefits that are financial, especially that are more concrete versus the connection to previous generations and the benefits of helping the world.
Yeah, I think those are coming with your legal and also some of your management decisions that you'll make in the next couple sessions that we're having.
Right.
With I think mentioned the ecological benefits there. We mentioned that with the parcel sizes, as those parcel sizes get smaller and smaller, it's just harder to manage. And get, you're looking at economies of scale to pay for, certain management activities on that forest. So what happens with just becomes unmanaged, we get invasive species and everything there, and forest health declines. So that's the concern there. Yeah, there's certain, financial, I think with financial things for the next generation, you have to communicate them. Financial things with forest land ownership, it's kind of a long-term asset, and it's not, so communication is important, how that ownership will work, and the financial benefits of it, potential in the future. But having to be aware it's not like a paycheck every time, but it's, a long-term thing with payouts, but it can be very lucrative too. But it's just not going to be like an every year thing. So I think that's important, getting them involved in that management decisions early on, so they're aware of these sorts of information.
Thanks, Phil. Linda asked, our family farm is incorporated, so in that sense, we all share in the farm and forest. We would like to keep the farm. The issue is management more than ownership. What about dividing roles, managing versus recreation versus gathering at holidays? Is there a way to incorporate outside management?
Oh, absolutely. If you want to do an outside management team, you can certainly do that. We deal more with, family management operations, but it's important to understand that those management roles need to be out there. And we talked about 6.5 years for transition of ownership, but it's also 6.5 years for transition of management. So all those things are possible. I would certainly include, and it sounds like you already have, since you have an incorporation, I would certainly talk to your financial management team about those management opportunities, because that's important. And since you already have, you've taken that first step in those first couple steps, I would certainly include those folks in those conversations.
And I might mention natural resources professionals, your consulting forester, the people who are doing the work on the property now could be the leads on that kind of management.
Yeah.
They have, you could set up contracts or whatever. Another question is, what are ways to pass on resources to keep the farm going, as well as passing on the property, which might otherwise be a burden?
Resources, I assume are you thinking farm equipment? I'm not sure where we are on resources.
I figured financial,
Okay.
tools and financial.
Yeah, so there are lots of ways to do that, and that goes with what tool you want to use. So if you want to use LLCs or trust or corporations, all those are ways to do that. Again, it goes back to those financial professionals that can help you, and those legal professionals. So, again, Phil and I, we can't answer financial questions and legal questions, but we can point you in that direction of making sure you have a really good advisory team helping you with those questions. So I would certainly send that question to your attorney and to your financial planner.
Yeah, just being aware of what assets, what tools the next generation needs to adequately manage that, and communicating with them like, okay, you're going to get this. What do you need to keep this going, and then develop a plan how to execute that, and getting your management team, your advisory team involved in that.
Part of that would be recognizing yourself what your annual costs are versus your annual income, and coming up with, a discussion with them about how to meet out those resources you need. Another question was about capital gains on property in the family for 130 years.
Yeah.
Oh, so, yeah. Go ahead, Phil, if you want.
I think a lot of people aware with looking at the timber sales and everything. The capital gains, we talked about the step up in basis. So when that transfer happens, you get that step up in basis. So basically your basis resets there. So if it's, you said 130 years in that family, but the ownership might have been changed depending how the ownership is. So that step up in basis probably has changed in those years there. And we'll talk a little bit more about coming up about different when that step up in basis, and that's going to affect your kind of capital gains when you're looking at timber sales.
This one you might be headed to talking about later, but what are some tips and tools to help your family share your vision? Kyle, you had said that them understanding your vision was super important.
Yeah, it's super important. And the family meetings, you have to start having, if you have not already done so, the family meetings are so very important that you do that in your setting. At the kitchen table, and you're having those discussions. What is the goals? What is our vision? And how do we share that? But the first question you ask is who wants to be part of the farm? Who wants to be part of the forest land? Who wants to be part of the woodlands? And start those discussions from square one. So you have to start meeting and asking those questions.
Another one, has long-term leveraging potential carbon capture value become a thing yet?
I know we've had some discussions, and maybe Phil, this is more what you'll discover in just a few minutes, but I think there's more to come on that one.
Yeah, I'm not sure if Liz, have you done research? I'm not super up on like with forest land carbon storage payments, but I'm not sure how lucrative that is, compared, because basically you're gonna be signing away your rights for some management activities, to preserve forest land on there. And, so I'm not, you'd have to do the cost benefits, that what the payment's gonna be versus, you're probably giving up some rights like timber sales in the future.
Yeah, my information is that there are only a couple programs that are working in the Midwest. There's far more programs in other parts of the US. They tend to be on larger acreages. The finances aren't quite steady and recognizable yet. It tends to be a lot less money than we were originally told it would be. So some of that is still in the works. I'd be happy to share. I'll make a note to share some of that information with you so you can do your own research, because there is a little bit of money in those markets now, but not where we thought they would be by this time. Cindy asked, is there a way to reduce property taxes for acreage, including a home that is not a primary residence for the owners?
That's certainly a question for your financial manager.
Yeah.
That you start getting into those specific financial questions. Those are important for your financial team to discover and tackle for you.
I know the one thing we'll mention later is the not specifically the home, but like your forest land, you can be under the Indiana classified forests, and that's going to be reducing your tax burden for that one. But it wouldn't cover the house. You'd have to parcel the structure out from the forest for that.
Well, that's the last of the questions here for now. Phil, if you'd like to go ahead and continue.
All right.
And we'll
All right.
continue to take more questions as and have some more Q&A at the end.
Yep. All right. So now looking at a different sort of legal framework agreement, how we can use to transfer our assets or trusts. So these are legal agreement arrangements in which the creator, kind of called the grantor, they're going to put the assets in a trust account and transfer to that trust. And then they're going to name a trustee as kind of the person, kind of like with the will, the executor. They carry out the wishes of the person who put it there. And that's going to tell how the assets will be transferred to the beneficiaries that's all in documents. We've got there's a wide variety of trusts out there. Two kind of big ones. We've got revocable and irrevocable. So revocable ones, we write up these trust documents during your lifetime, and you can make changes to it. How the assets are distributed, what assets go in, and then once you pass, then that kind of trust is closed and things can't change from there, and then how the documents are listed, how it goes. Irrevocable trusts are, you put them in right then, and you can't change it at all, and then so that at that point the trust owns that asset. So a revocable trust, once it's closed after you pass, then the assets are owned by that trust and then distributed there. So there's lots of different options out there. Specialty trusts, I think Kyle mentioned one for like special needs, how to provide for those individuals. We can change how the assets are distributed over a time period, or lump sums. There's lots of different things that can be discussed with an attorney to tailor to your specific situation. So we've got some advantages for trusts. So a revocable living trust, we can reduce some costs and time delays, avoiding probate. So once you pass all the assets go into ownership in the trust, and so they're not listed as your assets. So it won't go through that public probate process. If you have enough there, so Indiana, they've got with the small estate law there. If your estate is under $100,000, you don't have to go through probate. You just have to have an affidavit and with your wills and everything. So putting assets into different things like a trust can get you below that limit, and so you don't have to go through that probate process. You can receive some tax benefits. So with the revocable trust, they're still under your ownership as you're alive. So you can do that management and everything there. Trust can lessen potential challenges against the will. Again, one thing with trust, if you own property in multiple states, if you just have a will, you'd have to go through probate process in each state. But if you put those into the trust, then you avoid the probate process in multiple states. So that one state, it might be bad enough, by doing it in multiple states, you can increase your legal fees. So this can help reduce some of that. So things you have to think about, revocable trusts, they're not going to remove assets from your gross estate. Only gifting will do that. And you still own these assets as you're alive, so it's not going to shelter these assets from creditors if that something happens there. And there's going to be costs to set up, with the attorneys to get the legal documents filed and the transfer of assets and everything like that. Here's one example of a trust, a couple situations. So this marital trust here, we can have at time of the first spouse dies, the assets are transferred to the surviving spouse, and then they can get all income. They will have access to the income from that and the principal. And then at the passing of the second spouse, then you can transfer to the children. And then the taxes would just be over assets over that limit, that 13 million limit there on there. So we can set this up. This can be useful for second marriages sort of thing here. So you'd be able to provide for the surviving spouse, but then those assets will still go to your children, as opposed to if you don't have anything, the assets would be split up and not how you do it. Another example, this credit shelter trust. The surviving spouse is entitled to the income and principal to pay for health care and living expenses. And the trustee is going to oversee the assets, and then the assets would pass to the beneficiaries without taxes. And they can set up these things, especially if you have lots of assets, to have both of these going at once to avoid some of those taxes and take care of the situation. So just one example of things we can do. So like I said, there's different things how you can structure these things. If you don't want the beneficiary to inherit their shares immediately, like a big lump sum, because sometimes for certain individuals, that could be not a good thing for them personally. Like winning the lottery, you hear about people win the lottery and then in a year they're broke and their life is ruined. So you can set it up where they can get distributions at certain times, so kind of control that a little bit to protect them. We can set up trust terms in the will or a separate document, so the revocable trust document. Just because you have a trust doesn't mean you don't need a will. You're going to need a will, because not everything is going to be mentioned in that trust. Because I don't think you're going to put, grandma's teacup in your trust document. So that would be kind of more of those personal items you might include in the will. And so we can use it to transfer property at death. So at death, with the revocable trust, that goes into the trust, and then the trust documents say this property goes to this individual, then it's distributed that way. And again, you're going to avoid probate administration if you've got property in multiple states with it. And I mentioned that if you're in a second marriage and you have children from your first marriage, and you want the assets passed on to your children, but then you still want to take care of your current spouse and everything. So we can set up trusts to do that. Like Kyle mentioned, according to Indiana law, if you don't have like a will or anything that sets up anything, Indiana law says if your spouse and then the children, so the spouse is entitled to a certain amount of assets, and then the children. but then if the spouse passes, then those assets she got from your estate would go, if she had children, would go to her children, not your children. So if you want it set up, you can set it up to preserve assets for your children while still maintaining support for the surviving spouse. And it'll also provide protection if the spouse remarries too. We can set it up like that. Again, mentioned young children. You need a trust. So if you pass and your spouse passes, you can set up ways to care for them. If you have grown children with dependency problems, trouble handling money, bad marriages, we can set it up for longer distribution of those assets as opposed to lump sum, which might be harmful. The trust assets, so once they go into that trust, the trustee is kind of in charge of that and will take care of the distributions following your wishes as is outlined in the trust document. And the beneficiaries are going to receive those distributions on the terms you set. We can, lots of different things, options, like I mentioned before. We can have trusts be made for health. The distributions made for healthcare or education, daily needs until a certain age, like if you have a minor, or lots of different options. So I mentioned earlier with the questions, the step up in basis. We're looking at timber process, timber and that capital gain. So when does that step up in basis happen? So it's when that property transfers the name of the property. So if with a irrevocable trust, that's one that goes into the trust name right at when you set that up. With a revocable trust, it'd be at death, and then it goes into the trust, and then you get the step up in basis and then transfer there. So we can set up if these assets are in the trust, it can protect them from beneficiaries' creditors. So if they have problems with that, they're owned by the benefit. They're not owned by the beneficiary yet, but in the trust, so they can't go after, the creditors can't go after those in certain trusts. So you can control who inherits the property and exclude people if you want. So we can make it very flexible for that too. So on to another thing that was mentioned in the questions, limited liability entities. So common one is corporations, LLCs or LLPs, partnerships. These are legal organizations. And then talking specifically about land, the land is transferred to that legal entity, so that corporation is now on that deed for the land. And then the individuals who set up this LLC will be owned shares of that land. And so the idea is, the limited liability thing is, since the corporation owns the property, and if you get involved in a lawsuit for whatever reason, they can't come after those assets because you don't own those assets. They're owned by the corporation. And it's the same thing otherwise there. So it's protecting that liability of the members. So, and again, example in farming world would be a lot of farms set up a LLC for just their trucking. So, hauling grain and everything. Those trucks are owned by the LLC, and the farmland is owned by a different LLC. And so if there's a trucking accident and they sue they would sue the LLC who owns the trucks, but the land wouldn't be, covered under that, so they'd be protected. Part of this is important. We create these LLCs or LLPs. We're creating an organizational structure to make management decisions, and so this is more than just passing assets, although it can be used for that, but it's set up for the management of the property and different assets you're doing. So we can set up who's making the decisions in this, and how that is structured, so to be flexible there. And we can allow that next generation to be involved in management decisions before they're total owners of it. So that can be important, helping them have buy-in, and so they have a good idea of what goes into management of this property while you're still alive, And so they're not caught off guard, and we don't know what to do, everything once they're fully in charge. So things we need to think about when these are set up. There's certain rules you have to follow. So we're gonna have to set up its own bank account, and we need to run it like a business. So part of that in the organizational documents that you have set up is they're gonna tell you you're gonna have annual meetings, and we need to document that. So even if you are the only member, you own all the shares in this LLC, you still need to have an annual meeting, at least an annual meeting with yourself. So I've heard of individuals saying, sit down, they have a meeting with themselves, and they take minutes and everything and document that. Because if you don't follow those rules and something happens, and you're getting sued for whatever reason, and they come and ask you for, we need your documented minutes from your meetings, like, well, I don't have those. And then, well, since you're not operating like that, you don't get the protection of that limited liability. So that's the thing you have to do. So here's kind of example, this diagram showing, so a husband and wife, they own the land. And so they would, setting up this limited liability entity, corporation, partnership, they would transfer ownership to that entity. So they had owned the property previously, and they transfer it to the organization. And now they're, they set it up so they're own all the shares to this corporation, and they determine the management. Depending on how you can organize it, we can use this as a process to transfer ownership and management to kind of the next generation. We can structure it as inheritance. So you can set up in, will or other documents that my shares in this corporation go, this many go to this kid and this kid of my children or individuals. You can do gifting. So as you're alive, and transfer part of that ownership in that entity to them. So we can have flexibility there and get them involved. We can do a lot of different things with the structure. So it's can be flexible on that. So we can have units, we can have non-voting members involved. So you can have people that come to these meetings and know how things are run, but they don't have kind of a voting say in them at this point. And we can control how these are passed on to certain members. So we can set up transfer restrictions to maintain continued desired ownership. So some people might want, I want to pass it on to my kids, but I don't necessarily want to pass it on, have their spouse be ownership. So we can set it up to who can inherit and own shares in this company. I think Kyle mentioned there, if you pass on, you can have joint ownership. If you say in your will, okay, my 3 kids are going to own this land, and they're all 3 on that deed. One of them says, well, I want to sell, and unless the other 2 can get the money together to buy out the person, they're going to have to sell the whole property. So you can set up terms for like a buyout of another member if they don't want to be involved in that anymore. And so we can make it discounted, that appraisal rate, so they're not paying full value for those shares. You can specify payment terms of it. So we can have a long-term payment, so it's not like they have to come up with 1/3 of the value of the land next week. We can set it. You can set it over a time period. We can set interest rates, and to kind of discourage exit, keep them in there, and also make it easier to maintain that family ownership of the land. We can gift those shares. So the annual exclusion. So I think you can gift $18,000 per year from your estate, while you're living, and avoid that some of those tax liabilities there. We can include different things like mediation, arbitration language. If a dispute arises within the members. So how are we going to solve conflicts, which we'll be talking about conflicts within families in the next couple sessions. So when you're getting these documents, the legal documents setting up these entities, you're going to want to involve that next generation in that. So like we said, having them on board is going to be crucial to having it be successful, because if you said, well, this is what we're doing, and just hand it off and the kids aren't on board, it's not going to work, and it's kind of could be doomed for failure. So having them buy in, negotiations, say, we'd rather have it done this way instead of that, take those into consideration on there. So things you have to think about, you're going to have more fees. We're going to have legal costs, drawing up those documents for the corporation, the cost of transferring the land into that LLC or LLP. And so you have to get appraisals for that land values for IRS purposes there. And the IRS could dispute that, so that could throw a wrench in it too. Since the property is owned by that partnership or corporation, that legal entity will have to file its own tax return, have its own separate checking account, so you have to manage that. And then depending how it's set up, we need to do proper allocations if there's any income. So I mean, forest land, might not be typical to have lots of annual income, but so when those disbursements happens, do that properly according to the distribution. So step up in basis, in this case, that step up is going to occur when you transfer ownership from yourself to that LLP or LLC there, and so that step up in basis happens then. So and then if you pass and your shares go on to your kids, that step up in basis won't happen then, because it's still under the ownership of that corporation. The shares changed ownership, but the corporation stayed the same. So the same entity is on the deed to that forest land. So that step up in basis would only happen then. All right, those are a couple things. Think about some legal options to consult. We'll talk about some professionals you might need on your team. The one thing you need to think about is long-term care. So looking at statistics, most people are going to need some type of long-term care as they age. There are different ways that this can be covered. Medicaid is one of the most common that people use for long-term care, paying for that. But you have to meet asset limits and income levels. So you have to be below a certain level. And it kind of depends on, there's lots of different rules with this, what assets are counted towards this. It's kind of with farmland and everything like that. There's lots of intricate rules. But so basically, if you want to tap into that, you qualify for Medicaid, you can't have a certain amount of assets. And you can't just go, well, I'm going to try and qualify for Medicaid tomorrow, and I'll transfer my property to my heirs so they can have it, and I won't have that anymore. Medicaid has a 5-year look back period. So go back 5 years after you apply and see if you did any sort of things like that, and they could try and claw back some of that money there. So this can be very complicated, and there are attorneys that specialize in kind of this Medicaid and kind of protecting assets in there, and know all the rules, because it can get pretty detailed in there. So seeking legal advice there. There's also private long-term care insurance out there that you pay in annually. You just have to look at the policies and then the costs and see if any of that would work in your situation, and compare those. So one thing you mentioned that is important to a lot of forest landowners is they want this land to stay in forest forever. So that's one of the top priorities for people owning forest land. So, if you think 3 generations down the road, things don't go right, your heirs could do something, sell the land, get developed. So there are certain ways that you can kind of try and protect that land. So conservation easements are one. I think Liz is going to talk in more details on that in a future class. So basically, you get paid. They're buying development rights for that land. You're going to still own the property, and it's not going to be open for anybody else. But they're restricting how you use it. So one big one in Indiana doesn't apply to all land, but is this wetland reserve easement with the NRCS, and so they're by development rights. It's got to be like wetlands, so it wouldn't apply to all forest land, but you'd still own it, and it would stay with that property even if you sell it. So they're buying the permanent rights for that. So it's not going to get developed ever with that program. So we mentioned the classified forest program here in Indiana. It's not really an easement, but it could work to encourage heirs to keep the land in forest. So basically, when you enroll that program, you get a tax break on the land, so make it pretty cheap to own. But then there are penalties to try and get it out. So you have to pay some penalty fees and then some back taxes there. So kind of discourage people there. But it's not a guarantee on that. There are some private ones, so land trusts. I think there are some land trusts, not too many in Indiana, that are buying conservation easements too as well. But there's also people you can gift the land to land trusts, and they'll keep it in forest and natural areas too. So there's several around the state that you can talk to. All right. So we've Kyle talked at the beginning about getting your kind of vision and getting the family on board. And so how are we going to execute that plan? What is the best way? We're going to need a kind of a planning team. So these are some potential members that we could use in the process. Attorney. So attorney would be useful in making legal documents and doing things the right way that they hold up. CPA or financial planners, they're going to have experience, will know about the tax situations and how we can structure things to minimize the tax burden when we do the transfer or passing on to the next generation. A forester would be useful if you need to have appraisals done for transferring a property like into the LLC. If you have a consulting forester you work with, also working with them, introducing them to your heirs, so we have that continuity of management who they know to go to and rely on. Has been helping with management of that land for years. Another thing you can have is a mediator. This would be in case if there's a kind of a family conflict, a dispute on some sort of thing. This person would be a disinterested third party that help with communication. So make sure the people are hearing each other, getting the message across so they can resolve that. So, extension educator with Purdue, we could serve that role, or another one could be a clergy in that too role. So selecting your team members, you want to go about this in an organized way. Consider it like you're hiring an employee for a business. So you want to develop a job description, what you want them to do and accomplish for each of those members of your team. And you're going to want to interview potential members. So finding out who you possibly want. So you're going to ask around different friends or other landowners who they have used for different things, if they have any recommendations. Ask other professionals. So if you already have like a CPA you work with, and see if they know of any attorneys that kind of work in this area that they would recommend. Or if you have an attorney, recommend a certain financial planner. There's different referral services that you could use. But you'd like to have at least 3 names for each professional you'd want to work with to begin the process. And so some questions you want to ask them, you want to ask about some example ones. You can figure out some of your own that kind of specifically apply to your situation. So what is their past experience with similar situations? Have they worked with other forest landowners or maybe farm landowners to transfer assets in that way? Ask if they could provide references from other individuals that they worked with that similar things. So this may or may not work depending on confidentiality. How long have they been working in this field and doing these sorts of things? And what type of credentials do they hold? And how long do you think it would take this whole process for them to complete that process of what you want to get done? Some other ones you could ask for examples of plans or samples they've used, how they've worked with other clients that you can review. Ask them to provide a clear breakdown of their fee structure. So when are they going to be billing you? And so be aware of that and how you're using their services to maybe minimize what your bill will be. Think to yourself, are you comfortable working with this person? Can you communicate effectively with them? You think they would do a good job? Would your family be comfortable working with a person after you're gone? So certain things they're going to have to come back with them. So making sure your family's on board with this as well. So after you've got your team member selected, next you want to schedule a kind of a meeting with them. You want to keep a first meeting short, hour or less, and then you can lengthen the other ones as we go. The first meeting, we want to give overview expectations for the outcome of your planning process in subsequent meetings. So give them the kind of vision. So, we want this property, this asset to transfer to our kids so they can continue managing it and enjoy it for years to come. That could be an example. And scheduling these follow-up meetings. And it's always good to have an agenda to keep on track there. So going forward, you want to know what your goals are. So you mentioned there, we want to keep the forest in the family, pass it down to the next generation and their kids. Knowing those goals and having the next generation on board with those goals. So communicating with your family on those and make sure everyone's on the same plan. Like Kyle said, getting a plan can take a while. So average, 6.5 years to get kind of a plan started and kind of completed, everything's in place. And some of them take longer depending on certain things. Talk about management transfer as well. But also, once you have the plan, we need some periodic reevaluation. So things change all the time. So we could talk about regulation, tax changes could happen, and we need to tweak our plan to adjust those to take advantage of that. Family situations change. So certain things could happen in your family. We need to restructure our plan to help meet needs of the family and take care of certain individuals or something could happen. So reevaluate your plan because, certain things I know in my family with my grandparents' trust, I think they set it up and they didn't change it because they still had old addresses on it, I think. And, so it's like 20 years out of date, they didn't update anything. And so it's a good idea to look at things if we need to update, change things. So, all right, I think that's the end of our talk for tonight. We can open up for some questions.
Sure. Thank you, Phil and Kyle. We really appreciate your time on the presentation tonight. If there's any further questions, feel free to put those in the chat box. I am going to share with you a survey. I will also send this out via email, but we would appreciate your comments and input on that if you would be willing to fill that out. I did see a couple questions in here. Right at the transition, how to establish the property lines for absentee owners to protect ownership. This is a little bit more about managing, but I think that's a good point was made there that the property lines better be pretty well set. Do you want to speak on that, Phil?
Yeah, I guess legally you'd have to get, to be clear with your neighbors. I guess, what does it say? Good fences make good neighbors. So legally defined, so have a professional survey out there, and then with that you can clearly mark it. So Indiana's got the purple paint law for good exact distance, but you don't have to like post those signs everywhere for like no trespassing. You can do paint purple on trees or fence posts certain distance, and that qualifies as like no trespassing.
Are there any other questions? Someone asked about the land trust, and I did note in the chat box that we will be discussing conservation easements in week 4, and we'll get into more detail there. I will be sending you all some documents to help to go along with the presentation. We have a heirloom scale worksheet that can give you a chance to kind of write down your thoughts and values about your property. I'll send a little bit of information on the timber tax website and the purple paint wall law. And I also have a really nice worksheet that can give you information to start filling out the details of how you manage your property, where things are located, who your advisors are. Just kind of get that on a piece of paper, a form that you can share with your family. So I'll be sending all those via email. Are there any other questions? I guess you guys did a great job tonight. Okay, there's one. If a neighbor or squatter established a hut, I don't understand. How many years can they use it before it is theirs and not yours?
I don't know, Kyle. I think this is adverse possession, right? Not sure
Yes.
you know the legal things.
I don't. I know that it gets very complicated very quickly, but I don't know all the guidelines for that.
Yeah, I think you'd have to look up the laws because that'd be adverse possession. So I think it varies state to state, but I think they are maintaining it as part of their property, and it might have to do they're paying actually property taxes on it too. So, but you'd have to look up the laws related to adverse possession.
There was a comment in here that a person's father established their tree farm and desired it to be maintained as such in perpetuity. He died, and the mother later transferred ownership to sister and brother, losing our basis step up and potential creating a clawback situation. Free advice. In retrospect, it would have made more sense for my father to leave to us in his will rather than our mother, so we could have kept the step up basis benefit and avoided clawback risks. And then I wasn't going to read that. I'd let people read it on their own because there was some information in there personal. But someone then asked, can you expand on the step-up basis and clawback?
So the step-up in basis it's kind of it relates to what we think about for capital gains. So capital gains applies to when you sell, timber. So I own this property, and then that tree, the growth of that tree counts as that capital gains. So the moment you take ownership of that property, that step up in basis. So if your father owned it for 50 years and he planted those trees, if he sold them at the end, he would have, all that tree growth would count as capital gains for him if he sold it. And you get that property, that step up in basis. So it basically starts at zero. Your growth for that capital gains tax restarts there. And so then if you do a harvest 10 years down the road, you'd calculate how much growth took place in that 10 years, or kind of estimate, and that's where a forester can help you with that, getting an estimate of that growth. And that would be that step up. That would be what so you'd just be charged you'd have the capital gains tax on that growth, and not like 60 years of it, just that 10 years of it. So the same thing kind of work, I think, with houses too. So, the step up in basis, if you inherit a house, happens there. And if you sell it, then it doesn't go back to the gains on that value when it was your parents bought it.
Okay. Sarah asked, with owners in common, did I understand that a minority owner could force a sale?
Yes, if a person has any interest in ownership, then it is certainly possible for a legal case to be made for that minority owner. So yes, it is possible.
And I'm getting word that I sent you the wrong survey link. So I'm sorry about that. I had multiple surveys set up for the multiple weeks, and I will send that out in an email. Are there any other questions? Well, it is getting about the time we wanted to wrap, so I think we'll go ahead and wrap tonight. I'd like to give a big thanks to Kyle and Phil and the Purdue Succession Planning team for this program. If you'll watch for an email, we'll talk about additional reading and in the future send you a copy of this presentation. Next week, we'll be meeting at 7 p.m. Eastern Time again for a session on managing family dynamics, where we'll talk about all the complications of working with friends and family. Thank you very much, and we appreciate you coming tonight.